Good afternoon and welcome to the Scaringi Law lunch break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Red flag laws have been in the news a lot recently. These are new laws designed to remove firearms from individuals the courts determine to present an extreme risk of harm to themselves or others. If someone is subject to an extreme risk order, they must relinquish their firearms and are prohibited from possessing any firearms for the duration of the order. But as I've explained here on the Scaringi Law lunch break, there is another statute in Pennsylvania that has been on the books for many decades, the Mental Health Procedures Act. Through this act, a law enforcement official, county mental health worker, or even concerned family or household member can seek to have a person who presents a clear and present danger of harm to himself or others involuntarily committed for a period of time, during which time that person will receive inpatient mental health care and obviously will not have access to firearms. An involuntary commitment does result in a lifetime prohibition on the Second Amendment rights to keep and bear firearms, though. In recent years, Scaringi Law has been blazing a path through our courts to have the Second Amendment rights of certain individuals subject to an involuntary commitment restored. That's because not all people subject to an involuntary commitment were actually suffering from a severe mental disorder that required inpatient care, and not all committed the acts required in order to commit them. Many of these instances are isolated episodes, sometimes triggered by divorce or death of a loved one, or some other traumatic life experience. And the individual is able to recover his or her mental health quickly and without the need of inpatient care. Often treating physicians who enjoy statutory immunity for wrongfully committing a person will err on the side of caution and issue the commitment. And perhaps the certifying physician believes the disturbance will abate within the 5 days the person is committed subject to Section 302 of the Mental Health Procedures Act. So one can see how there are people subject to involuntary commitments which result in the loss of their firearms rights who really should not have been in the first place. The Pennsylvania Uniform Firearms Act presents a statutory vehicle through which we, firearms attorneys, can petition a court of common pleas to find that insufficient evidence existed to substantiate the 302 involuntary commitment. A commitment under 302 affords no due process rights of any kind to the person being committed, and as a result there is ample opportunity for these commitments to occur despite the lack of evidence. So Scaringi Law will examine the commitment paperwork and the medical records to determine whether sufficient evidence existed to support the commitment. If we find insufficient evidence, we'll challenge the commitment in court and seek to have it expunged. We have been successful in several courts throughout central Pennsylvania, including most recently in Center County. Once we successfully expunge the commitment, our client's Second Amendment rights are automatically restored by operation of law. In this case, in Center County, we lost at the trial court level, but won on appeal to the PA Superior Court, which is a rare thing. We won this case because it was clear from the record our client did not take an act in furtherance of his threat to self-harm. The act requires a commitment if a person within the past 30 days, or the act allows a commitment if a person within the past 30 days attempts suicide or threatens to commit suicide. If he threatens to commit suicide, he must utter the threat and take a substantial step in furtherance of that threat. In our case, we had a threat uttered in the context of complaining about medical bills and the effect of certain medications, but there was no substantial step in furtherance of that threat. We also had a more generalized threat of harming other identified people. Those threats were enough to send the county mental health officer with a 302 warrant to our client's door, along with the police, to take him into custody. And he was taken into custody. He was seen by a certifying physician, and that physician committed him under 302 several years ago. He then hired us, and we filed a petition in Center County challenging that commitment. We argued the commitment should be expunged because there's no evidence our client took a substantial step in furtherance of the threat of suicide. Nevertheless, the trial court, like the certifying physician, upheld and issued the commitment. Again, physicians may exercise caution and overlook the absence of material elements to permit the commitment just to get the person into the hospital and treated. And that's what we're looking for, among other factors, in these cases. In this case, we were able to have the Second Amendment rights of our client restored by effective advocacy in the trial court and appellate court. Congratulations to Scaringi Law attorneys Brian Caffrey and Robert Sakovich for the win. If you or a loved one are ever subject to an involuntary mental health commitment and wish to learn how to restore your Second Amendment rights or your constitutional right to your good reputation, don't hesitate to contact one of the firearms attorneys at Scaringi Law. Well, that's about all the time we have today for the Scaringi Law lunch break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.